Good morning to everyone in Europe and good afternoon to everyone in China. Welcome again to the EU SME Center webinar series. This is Benoit Mizon. I'm one of the market access advisor at the center, and we're happy to see so many participants again at today's webinar. A quick word again about the center for those of you that are new to the center. The center is an initiative from the European Union to assist European SMEs in their approach to the Chinese market, to set up, develop and maintain commercial activities here. And we're doing that by providing information and advice and practical services to SMEs. Just for the ones that are participating for the first time to the webinar series, you can see that you have a number of tools in the webinar panel, and one of them is a text box where you can actually raise your questions. So don't hesitate during the entire webinar to raise any question you would have, and we'll try to address, as for every webinar, all the questions during the webinar. If we don't manage to get through all the questions, we'll ask you to help us to get and pose the questions directly on the website, and alternatively to register if you're not registered on the website yet. The advice that we're providing, as I mentioned, is on four different areas: business development, legal, standards and conformity assessment, as well as HR. And today we'll really touch on questions of legal aspects of human resource management in China. We have a number of different tools to help you in your approach to the Chinese market, and one of the ones that we have repeated to you extensively in the last few months is our diagnostic kit that Are You Ready for China, which is comprised by 4 different reports, as well as a self-assessment tool to identify where you stand in your approach and in your preparation to the Chinese market. So again, you've got the link there directly on the slide. We'd like to invite you to take the quiz and to see where you stand in your approach, and try to help you maybe identify some of the questions you want to raise directly with our experts at the EU SME Center. So as I mentioned, we've got several tools to support SMEs, and we're doing that through provision of expertise, but also the drafting and planning of reports, case studies, and guidelines. And today, in today's webinar, we'll touch specifically on one of the questions which a number of SMEs have been raising to us in the last few weeks, and it's really about how to cope with HR challenges in China, and specifically on recruiting and employing foreigners in China. That's a very topical issue, because yesterday, and our speaker will tell us more about this today, yesterday the new entry and exit law came into force, bringing along a number of changes and developments on how SMEs and companies altogether in China recruit and employ foreigners here. So with this, we have our expert who's been speaking already at our webinar series in the past, Johnny Choi, and Johnny is joining us from Simmons & Simmons. Johnny, thank you very much for being available to speak at the webinar today. With this, maybe I'd like to maybe pass on to you for a quick introduction about yourself and your activities here, but also then to directly not lose any more time and go directly into the subject matter of today. So thank you very much again for being here, Johnny.
Thank you, Benoit, and hi everyone. Welcome to the webinar. My name is Johnny Choi, an associate at Simmons & Simmons, based in Beijing. And Simmons & Simmons has one of the largest employment law groups in China. I'm one of the 2 Beijing associates, and we have 3 other lawyers in Shanghai and 1 partner. And then we also have 7 or 8 lawyers in Hong Kong. So I myself, I've been practicing and specialized in the area of PRC employment law since 2005, and advising multinational clients on various issues relating to PRC employment, such as hiring, termination, employment handbooks, and then day-to-day employment advice, and also today's topic about hiring and firing foreign nationals in the PRC. So in today's webinar, we are going to discuss how multinational companies can get the necessary approvals for foreign nationals to work in China. We are also going to discuss the impact of the new entry and exit law for foreigners that Benoit just mentioned. We are also going to go through different arrangements for hiring foreigners in the PRC, and also tax implications for having foreign nationals work in the PRC.
Actually, with this, I think it would be good to start gauging our audience for today's webinar. Actually, the question that we're going to raise is not very different from the first poll we raised at the last webinar we did together a few months ago, Johnny, about employment and, well, recruitment and employment, legal issues in China. So it's the question I'm going to raise, and which should appear in your screens in just a few seconds, is really on what the main challenges are that you're facing when it comes specifically to employing and recruiting foreign employees to your company in China. And you've got the questions which has appeared now on your screen, and you have 5 different answers. A, the shortage of qualified workers and the high turnover, as well as the low retention. B, rising costs, which are due principally, and we'll talk a little bit about that, and we've addressed it actually last time, Johnny, the tax issues, social security obligations, etc. C, obtaining approvals for foreigners to work in China. D, all of these, or actually E, you don't have any challenges at all. I see that most of you have already answered, a good majority. So with this, I'm closing the poll and sharing the results with you. And I don't think that there is anything surprising here, Johnny, right? It's about half of the respondents have answered that really the main challenge is the question, or maybe what is blocking them from employing more foreigners is the question of the approvals that they need to obtain, followed directly by the rising costs. And I guess that one of the ones that companies have in mind answering that are the recent changes over the last few years on social security. And, well, the other answers are really only marginal, but obviously, and I can see here, none of the companies have had no problems. So it is a challenge to employ foreigners here, it seems.
Yes, definitely. With the new entry and exit law that just came into force yesterday, the obtaining approvals for foreigners to work in the PRC is becoming more complicated, and also the authorities are stepping up the enforcement, whereas in the past, and this is going to be a consistent theme throughout this webinar, the authorities are not very strong in the enforcement of foreigners working in China getting the necessary approvals. The new law, and then also an implementing regulation that will come into force in the future, they're going to step up the enforcement in this area, and also the rising costs relation to both social security and also tax implication for having foreigners to work in the PRC now seems to be relevant to companies.
It's interesting actually to look at the first answer, because here the question of well, we grouped a number of answers together, but questions of shortage and turnover and retention, which is typically one of the HR, the general HR challenges in China, is not so much one that is touching on foreign employees. So it's interesting in that to compare a little bit the answers that we received from the past webinar and today's webinar, although it's difficult, of course, to completely compare it. But with this, I'm just hiding the poll, and then I'll let you go through the next slide, Johnny.
Okay, so we are going to discuss first about getting the necessary approvals, the work visa and work permits in China. In order to work in the PRC, a foreign national is required to obtain a work visa and a work permit. And foreign nationals who enter into the PRC for things like just a business meeting, they can obtain a business visa. And I'm going to go into that later. And then I also mentioned there used to be a lack of enforcement on application of work visa and work permits. Here you will see that the eligibility for a foreign national needs to have the position they need to fill in should have the special need for the foreigner. There should be a shortage of suitably qualified local candidates, and the foreign national should have the relevant postgraduate experience, generally 2 years regarding the position that they're going to fill in. As I mentioned, this eligibility criteria was not usually strictly enforced in the past, and especially the first 2 points, the special need and the shortage of suitably qualified local candidates. And this is because the laws and regulations are not very clearly defined, and there's no guidance regarding the special need and suitably qualified local candidates. So with the introduction of the new law, and then also a draft regulation that's in the pipeline, it's anticipated that there will be some guidance regarding this, and so that they will be stepping up the enforcement in this area. So the steps that that a company needs to go through to obtain approval for a foreign national to work in China. Firstly, the company needs to apply for an employment license for foreign employees in China, and then the company needs to apply for an employment visa notice issued by the local Foreign Economic and Trade Committee. And then the company needs to apply for not the company, the first 2 steps are the company. Then the individual needs to apply for a single entry work visa with a Chinese consulate or embassy outside of the PRC at the home country of the foreign national. And part of the application materials are the 2 documents that they obtained in the first 2 steps. Then after obtaining the single entry work visa, the individual will enter into China, and the foreign national will go through compulsory medical examination, which is conducted by a certain medical clinic, designated clinic in China. After that, the company will apply for a work permit for foreign employees in China with the local labor authority using the medical certificate obtained through the medical exam. And then after obtaining the work permits, the foreign national needs to go to the local public security bureau to obtain a residence permit. Then the documentation is basically complete. The rest is the company needs to register with the tax bureau so that they can pay individual income taxes in respect of the foreign national. And then if there are any personal items that needs to be shipped from abroad, then they need to register with the customs authorities as well. Special cases. So as I mentioned, if a foreign national comes into China for business meetings, then they are not required to obtain a work permit. If a foreign national is coming into China to work for less than 3 months, and the employment contract of the foreign national is signed with the home entity, the entity located in the home country, and the salary is also paid by the home country entity, then a work visa or work permit is not required. For a foreigner who is above the statutory retirement age, which is 60 for a male foreigner and then 55 for a female, generally they are not eligible to obtain a work visa or a work permit. But in some special cases, depending on case-by-case consideration by the Labor Bureau, it could be allowed. And then another way to apply for a work permit or work visa for a foreign national is through the Foreign Expert Administration. If successful, they will issue a foreign expert permit rather than a work permit, which allows the foreign national to come to work in China. A legal representative of a foreign investor company or the chief representative of a foreign company's representative office in China are not required to go through the same steps. They can apply for a work permit and a work visa at the same time inside the PRC. And then for Hong Kong, Macau, and Taiwan residents, and by that I refer to those residents of these three jurisdictions which hold a mainland travel pass, a pass to travel to mainland. They are not required to obtain a work visa. They can use that mainland travel pass and then enter into China and then obtain a work permit. And then there's also this type called special talent under the new entry and exit law, which I will go into detail shortly. The special talent is usually policies introduced by either the national government or local governments regarding attracting foreign talents to work in the PRC, and they're usually aimed at overseas Chinese, those Chinese citizens who obtain foreign nationality, and then they are aiming to attract them to come back to the PRC and work in major industries like state-owned banks and financial institutions, etc. The new law on entry and exit of foreigners, it was passed in 2012 and it came into force yesterday, 1st of July, 2013. Together with the draft implementation rules published on the 3rd of May, there is a proposal to basically introduce major changes to the regime for entering and exiting China. The draft implementation rules hasn't been passed in final form still, despite the law having come into effect. But the draft implementation rules, because it's very detailed, it may be this reason that the government is still deliberating the provisions. But the changes, the key changes, we do not anticipate to be different if the final version comes out. So these proposals are to redefine or split most of the existing visa categories and add new ones, introduce a new residence permit regime, which proposes 7 categories of residence permits. It re-emphasizes and clarifies the definition of illegal employment under the new law.
I have a quick question here, Johnny, because I think that's a question that most of the SMEs are wondering about, maybe on the point you just made. Do you have any idea or on the timing when the draft implementing regulations might be enacted? In the absence of enacted implementing regulations, what does the rule or the new law already prevail? How should they be implemented, etc.? Because obviously, in the absence of the implementing regulation, it's difficult to know specifically how to implement it. There is still some legal uncertainty here.
Yes, because the draft implementation regulation hasn't been promulgated, but the new law is in force from the 1st of July. So the new law is going to make certain changes, but there are no detailed rules, which means that in the meantime, there is still quite lack of clarity on what's going to happen. But we assume that the existing regime is still going to be in place for a while, until the draft implementation regulation comes into force. Because the new law has already been implemented, we expect that the draft implementation rules is going to be finalized shortly, and that's the aim of the government, to finalize it as soon as they can, so that it actually is going to match up with the new law.
Okay, thank you for that. So let's move on maybe to the question of the new splits of the existing visa, because actually I think there is quite a number of changes here in the categories of visa existing.
So there are new types of visas and also redefinition of visa categories. I'm not going to go through that in detail. You can also read these changes in your own time. So, for example, for F visa, visitors visa used to include both business and non-business visitors. Now it becomes an F visa, which only limited to non-business visitors, and an M visa, which is for business visitors. And then there's also redefinition of travel visa, and then the categories become more specific now, depending on the purpose of the entry. And then, as I mentioned, there's also a special talent visa. So this special talent visa was already mentioned in the new law, but the implementing rules tries to make it more specific, but it still hasn't been finalized. The special talent visa is still currently unclear. What's the criteria, etc. But if the new implementation regulation comes out, it should be clearer. So basically, the special talent visa is about the things that I just explained, is to attract overseas Chinese to come back to China, subject to local or national policy requirements.
Maybe a question here, because it's a little. Can you maybe illustrate with an example where an SME would go for? I mean, who is really suitable for the R visa? I understand that, of course, this needs to be clarified in the implementing regulations, which would shed more light on this. But as the rules now on the Z visa and F visa are becoming more stricter, the R visa is probably the way to go where this is possible, of course. So what would be a typical example? Thinking specifically of what would be the need for European SMEs, so looking at an engineer or something.
The R visa, looking at existing rules regarding attracting talents to come back to China, is mainly aimed at research and development, or financial, or types of positions, and then especially to those not purely foreign nationals, but those people who have obtained foreign nationality, but originally they were Chinese citizens. If you have these types of individuals who are candidates and they are going to work in research development or technological development, or finance type positions, then it may be possible to use the R visa.
Okay, so not the kind of visa for a particularly talented salesperson I'm trying to attract from abroad, for instance, then obviously. Okay, well let's move on to the next part then.
Okay. The draft regulation also introduced a new residence permit system, and this new residence permit system, again, it was referred to in the new law, but there's no specific details. Under the current system, a residence permit is divided into two types. One is the normal residence permit for someone who is going to stay in China for 1 year or longer. The other is the temporary residence permit for someone who is going to stay in less than 1 year. Under the new system, there's no distinction between temporary or the normal residence permit. It is all the same, but they divided the residence permits according to the type or the purpose of the stay or the type of visa. Under the new law, a foreigner will be illegally employed, and then there's a definition of illegal employment for under certain circumstances. The new law actually, even before the new law, there is a prohibition against foreigner working in China illegally, but then the new law is just re-emphasizing this and making this more clear. And in the draft regulation, it further defines or clarifies what the new law says. So, for example, a foreigner will be illegally employed if the work location of the foreigner or the employing entity of the foreigner specified in the work permit is different from the actual location or the employing entity. So this confirms that, for example, a foreigner can't be employed by two employing entities in the PRC. So all this is just to re-emphasize, because in existing law or the law before 1st of July, illegal employment of foreigners is already prohibited. But they introduced this definition and also further clarify the definition. So it shows that the government is going to be taken seriously, the illegal employment of foreigners issue.
Here, thank you, Johnny. Here again, I think it would be useful maybe if we could get practical, because as you mentioned, one of the points where the employment is illegal is where a foreigner is working beyond the scope specified by the work permit, whilst at the same time the eligibility for foreign workers is only in areas where there is a shortage of suitably qualified local candidates, etc., amongst other points that you mentioned already. That's extremely difficult to actually quantify. So should SMEs be worried about these clauses? Is it going to be enforced very, very thoroughly? Is there some room for maneuver, or do you see this changing quite dramatically, or is the situation in practice not going to change so much? Because again, it's not so black and white really about how to identify who is really eligible or not.
Yes, one of the things that keep coming up as the theme of this legislative development is whether the enforcement is going to how the government is going to enforce the new law and the new regulations. Is it going to be just another change in the paper of the law, but not in practice? Or is the government really going to step up the enforcement? We expect the government that there's going to be increased enforcement in the area, because of the intention of the government is very clear. The purpose is really to prohibit the three types of illegal activities. One, the illegal employment, illegal residence in China, and illegal entry into China. So and then for the draft regulation, one of the reasons for the delay in publishing the final version, I suspect, is because the implementation issue, and there's some worry by companies that they're going to immediately step up the enforcement. So especially because the implementation regulation hasn't come into effect. So the initial period, the enforcement is probably not going to suddenly become much stronger than before. But gradually, and then especially with the publication of the implementation regulation, the enforcement will become stronger regarding in this area of illegal employment and illegal entry and illegal stay.
Okay, thank you. And obviously, the new law is also trying to pump a little bit more deterrence into the system, as we're going to talk about penalties now.
Yes, that's correct. So the new law increased the penalties. So for a foreigner who is coming to China work illegally, the penalty is increased from 1,000 RMB, which is very little, to 5,000 RMB to 20,000 RMB. And then in serious cases, the foreigner can be detained for 5 to 15 days, and in addition to the fine of 5,000 to 20,000 RMB. For the employer, the penalty has been increased from 5,000 to 50,000 RMB to 10,000 per foreign national who was illegally employed, up to a maximum of 100,000 RMB. And the illegal profits in respect of the illegal employment can also be confiscated by the authorities. Under the new law, as I mentioned, there is supposed to be a catalogue to guide the foreign employment, so to clarify the definition of what is meant by lack of local candidates or a special need for foreigners. However, this catalogue also hasn't been promulgated by the Ministry of Human Resources. So again, it remains to be seen, what kind of employment will be open for foreigners once this catalogue is published. But it is expected that with the new catalogue being published, then there will be more clarity and more enforcement of what is meant by foreigners who have special need to be working in China, and also with what is meant by lack of local candidates. So this area also need to monitor closely. So implication of all of these changes, the authorities will review the employment and residence arrangements of foreigners in the PRC with greater scrutiny. The employers, as a result of these changes, the employers should audit if you have existing employment arrangements for foreigners, then you should audit those employment arrangements, both for foreigners working temporarily or long-term in the PRC, to ensure that they do not fall foul of the new rules, and to keep abreast of developments regarding any changes to the draft regulation and also the enforcement situation after the effective date, to ensure that foreigners can enter into PRC with appropriate documentation and remain in China accordingly. So we now move on to employment arrangement for foreigners. So for a company who wishes to hire a foreigner to work in the PRC, there are 3 types of arrangements. The first type is a secondment arrangement, and that can be applied if the foreign company has a representative office or a joint venture or a wholly owned subsidiary in China. With a secondment arrangement, the PRC entity can control the employee and pay the remuneration to the employee. The overseas entity can also retain the right to fire or discipline the employee. Points to note about the secondment arrangement. Firstly and most importantly is that if in a secondment arrangement, if it lasts for 6 months or longer, then the foreign company or the home company may establish what is called a permanent establishment in the PRC. And the permanent establishment issue, I will elaborate later on in this presentation. But basically, it means that there are tax implications for the wider group, and not just to the individual or to the PRC entity. And then secondment arrangements, sometimes it may not be accepted by local labor bureaus. For example, we understand that in Tianjin, they do not accept a secondment agreement when the company apply for a work permit for the foreign national. they only accept a local employment contract. But in other locations, such as in Beijing or Shanghai, a secondment agreement is acceptable. So you don't need to, for purposes of applying for a work permit, you don't need to have a local employment contract. The second type of arrangement is direct employment, and that can be applied to a foreign company which has a joint venture or a wholly foreign-owned subsidiary in China. It doesn't apply to foreign representative offices because foreign representative offices cannot hire individuals directly in the PRC. So under a direct employment arrangement, the PRC entity will have the sole control over the foreign individual. And then, generally speaking, PRC labor laws will apply with respect to termination of employment and other issues. And as some of you may know, the PRC employment laws, especially with respect to termination of employment, is very stringent, and there are only very limited grounds to terminate. So this is a disadvantage to using the direct hiring arrangement, but there is an exception which applies in Shanghai. In Shanghai, a foreign national and the local entity employer can enter into an agreement, and that agreement can prevail over the mandatory PRC labor laws. Whereas in other locations, even if an agreement, even if there's an agreement, if the labor law has certain mandatory requirements, then the labor law prevails. The third type of arrangement is the dual contract arrangement, and that can be applied to a JV or a wholly foreign-owned subsidiary. And that is a kind of a combination of the two types of arrangement above. The local entity can retain control over the employee, and the overseas entity can also have some responsibility to pay the remuneration or fire or discipline the employee.
Let's actually gauge the audience on this slide, Johnny. So with this, I'm just launching the second poll, which is about which employment arrangement companies adopt for foreigners working in China, and it's really the three possibilities which you've mentioned, so secondment, direct hire, or dual contract. So I'm giving you a few seconds to answer back to that question. Only very few votes for the moment. So there isn't really any. Well, there is gradually now one of the options which is coming out. So I'm just going to. I'm going to hide the polls and share the result with you. So I'm closing and sharing. So the direct hire seems obviously to be the most important one, with almost 60%, followed by secondment to about 30%, and then only about 1/6 on dual contracts. Is this something which is different from my experience or practice, Johnny, or very much in line with what you're used to see?
My experience and practice is actually there's a change over time regarding which type is most popular. Secondment used to be the most popular arrangement because it was viewed as advantageous that in a foreign secondment arrangement you don't have to apply the local labor laws in the PRC. Yeah. So that as is showing in the next slide, it is very so that you can avoid the application of the PRC labor laws, which is very restrictive. And but this position changed in 2010 because of a tax circular, which means that in a secondment arrangement, it is possible that the the parent company, the home company, can be considered to have established a permanent presence in the PLC for tax purposes and then become subject to corporate tax laws. So from 2010, it has been more common to use direct hire arrangements. So that's why in the poll, the direct hire arrangement is most popular. And recently, there's some companies have now been considering using the dual contract arrangement, because the dual contract arrangement has certain flexibility in that it can also allow the home entity to have certain responsibilities with respect to, for example, the foreign national wants to have some remuneration paid in the home country, or to have the foreign national transferred back to the home entity once this secondment is over. With a PRC direct hiring arrangement, the contract with the foreign national must have a term of 5 years or less. So you cannot sign a contract which is open-ended or has a term of more than 5 years with a foreign national. And then, as I mentioned, PRC labor laws apply. In terms of termination of employment, there's one method of avoiding the application of PRC restrictive laws regarding termination is that some companies, they choose to cancel the work permit of the foreign national. At the same time, they terminate employment. And this allows the company to argue that because the work permit is canceled, so the foreign national cannot be reinstated back to the original position. So that reduces significantly the risk that a company would face in terms of illegal termination of a foreign national. And then, so that's one of the ways that you can get around the disadvantage of a direct hire arrangement. And then, as I mentioned, a dual contract arrangement allows some flexibility for transferring the foreign national back to the home company. We now move on to the tax implication for foreign nationals working in the PRC. A foreign national is subject to the PRC individual income tax on income received while working in the PRC if the foreign national resides in the PRC for more than 90 or 183 days, or if the PRC entity pays for his or her salary. So if the PRC pays for the foreign national salary, then regardless of the length of stay, the foreign national needs to pay the individual income tax. But if in other situation, then the foreign national will have to pay PRC individual income tax if he or she stays in the PRC for more than 90 or 183 days. And how to determine whether it's 90 or 183 days? It depends on whether the home country has a double taxation treaty with China. If it doesn't have a double taxation treaty, then it is 90 days. If it is a country which has a double taxation treaty with the PRC, for example, most major countries like the US or UK or Hong Kong, then it is 183 days.
Okay, just to confirm, we're talking about working days or calendar days?
Calendar days.
Okay.
And then for a that rule applies to the income for a foreign national received while working in the PRC. When a foreign national works in the PRC and resides in the PRC for 5 years or longer, then the foreign national becomes subject to PRC individual income tax on his worldwide income, so not just the income while working in the PRC. And there's one exception in terms of the legal representative for a foreign investor company. and a chief representative of a representative office, they are not entitled to the benefits of the 90 or 183 days rule that I just mentioned. So that means a foreign company's legal representative or chief representative, they will be subject to PLC individual income tax on the first day they arrive in the PLC to work. And then the last point is that the PLC entity has a withholding obligation in respect of the foreign national's individual income tax. So if a foreign national didn't pay his or her individual income tax, the PLC entity, the local entity, is responsible for and the tax authorities can pursue the PLC entity for the unpaid taxes. Tax benefits. So foreign nationals are eligible for certain tax benefits that local PRC citizens are not eligible for. The monthly deduction from taxable income is 4,800 RMB, which is slightly higher than local nationals. So when a company pays the salary to the foreign national, 4,800 RMB is first deducted from the salary in terms of the taxable income. And then foreign nationals are also eligible for non-taxable benefits, which include allowances for housing, meals, and laundry and relocation expenses, provided that they are received in non-cash form or on a reimbursement basis. They are also eligible for reasonable allowance for business trips within China and abroad. They are eligible for allowances for leave to visit family, language training, or children's education expenses, provided that the costs are considered reasonable by the tax authorities. So all of these, the 4,800 deduction and all of the allowances that I just mentioned, they can all be deducted from the taxable income of a foreign national. The individual income tax rates in PRC are progressive and range from 5% to 45%, with the highest marginal rate of 45% being applicable to all amounts of income in excess of 80,000 RMB per month. Now we move on to the permanent establishment issue that I just referred to. The permanent establishment issue is applicable when a foreign national is seconded to the PRC to work for longer than 183 days during any rolling 12-month period.
So here there is a question on this specific point, Johnny. In this case, if an offshore company second 3 foreign nationals to China for 3 months, does that satisfy the requirement that the offshore company has seconded personnel to work in the PRC for more than 183 days during the rolling 12 months?
Yes, that's a very good question. And then many companies, I mean, not many companies, but certainly some companies that we know is trying to avoid the permanent establishment issue by seconding multiple number of foreign nationals to the PRC, but all of them stay in the PRC for less than 183 days. That doesn't work because the tax circular specifically mentioned that if there are foreign nationals, multiple foreign nationals who comes to PRC, then their length of stay is calculated cumulatively, so they add up the length of stay of the foreign nationals in determining whether the stay is longer than 183 days. Mm-hmm. However, if there's an overlap, so if all of the foreign nationals stay in the PRC at the same time, then it's only counted once. So any overlap of time is not counted. So the implication of the permanent establishment, as I mentioned, for example, in many cases it is common for a company in a home country wanting to second a foreign national to work in the PRC, and the home company may want to pay certain remuneration or compensation to the foreign national in the home country. So in that kind of scenario, the local entity will make certain payments to the home entity, and then those payments, because of the foreign exchange control rules in the PRC, the local subsidiary will need to explain the purpose of the payment to the overseas entity when trying to convert the currency of the payment. And then this is when the permanent establishment issue arises. So this transaction will allow the authorities to look into the purpose of the payment, and then it is at this time that a risk of permanent establishment will be considered by the authorities. So what does permanent establishment mean, or what is the definition of the permanent establishment? It is when an offshore entity seconds personnel to work in China, and then the offshore entity assumes part or all of the liability and risk for the work performed by the seconded personnel, and the offshore entity is responsible for reviewing and evaluating the performance of such seconded personnel. And these are known as the fundamental criteria. In making the determination about the fundamental criteria mentioned above, the authorities will consider the following reference factors. And the reference factors are whether the PRC entity pays the management fees or service fees or other payments of similar nature to the offshore entity. If there are payments from the PRC entity to the offshore entity, whether the payment is more than just the reimbursement of the cost of the secondee's wages, salary, social security, and other costs. And then they will also consider whether the offshore entity retains a portion of the payments made by the PRC entity instead of transferring all the amounts to the seconded personnel. Whether the PRC individual income tax is paid in full in respect of the seconded personnel, and whether the number of seconded personnel, the qualification, the salary, and work location are determined by the offshore entity. So basically, if there's any payment by the PRC entity to the offshore entity in respect of the seconded personnel, and the payment is more than just the cost, so that the offshore entity receives a markup of the cost, that's when there's a permanent establishment. And also, if the offshore entity retains control over or reviews or evaluates performance or takes responsibility for the work of the seconded personnel, then there's a permanent establishment. And the tax authorities may review the following information, which includes any contract agreements between the offshore entity, PRC entity, and the secondee, any management rules of the offshore or the local entity, which shows which entity is controlling the seconded personnel, and any information on the payments among the different entities. So the consequence of the permanent establishment determination is that the home entity will be subject to corporate tax, which is generally 25% on the permanent establishment's profits. So the good news is that the 25% corporate tax is just imposed on the permanent establishment, but it is still important to know that a seconded personnel will generate permanent establishment issue and wider tax effects on the group as a whole.
Thank you so much, Johnny. I think we're a bit getting short of time already, but before we take some time for some of the questions, we've actually received quite a lot of them today. Would it be possible to maybe give us a brief summary of really the most important takeaway points of today's presentation?
So, in summary, foreign companies should ensure that foreign nationals obtain the right documentation to enter, work, and stay in the PRC, monitor the developments on the new exit and entry law, consider the type of hiring arrangement if they need to have someone seconded to the PRC, and then consider the individual income tax liability and the permanent establishment issues associated with having a foreign national working in the PRC.
Thank you. Actually, that's quite useful, and it's already answering a number of the questions that we've received. We've really received quite a number of them, and maybe I'll raise only a number of them, if I may, Johnny. One of the questions we're receiving is from Ian in Ireland, asking if an SME parent company has a subsidiary in China. Is there any special working visa for the EU citizen that will get work between the two companies, so that you've mentioned? I think that the answer is that there isn't really, that it's all depending on the setup. I don't think there is a visa especially for that, but the visa will depend on the setup, actually, I believe, right?
Yes, that's correct. So there's no special visa, for EU citizen or, to work between the two countries. It depends on the length of stay within the PRC. Some of the rules I mentioned, whether it stays is less than 3 months or whether it's less than 183 days in terms of the tax implication. So, generally you need to obtain a work visa, as I mentioned, if it is less than 3 months. And then there's no contract with the local entity, or if the local entity is paying the remuneration. So those are the elements that need to be considered, whether they need to apply for the work visa.
Okay, thank you. There were, I mean, just going through to the next question, two of the questions that we received actually were specifically, I think, about, I mean, one of the points that you raised here in your final slide, which is that it's important to actually ensure that your foreign nationals obtain the right documentation to enter and work and stay in the PRC. And I think in practice, a number of companies have maybe used a number of loopholes in the law to have some people working for them. So basically, we're talking here about companies that are established abroad, don't have an office in China, but have foreigners working for them in the PRC. This has been a practice, but I think that even under the old system, this isn't practically possible, not on a constant basis at least.
Right. So yeah, this kind of arrangement is not permitted even under the old system, and under the new system is going to be even more risky because the increased enforcement of the entry and exit rules, and also they have divided up into more detailed categories of stay, so it allows more scrutiny by authorities, easier for them to tell whether you are here for what purpose, and so this kind of arrangements become even more risky for a company.
So when a company is dispatching one of their employees, or they're appointing a foreign national in China to set up a company for them here, what is the length of the time tolerance for actually getting all the systems set up? Because obviously there is the representative office or the WUFI, it takes some time to set up. So in those cases, you need to go through some of the other visas that you mentioned. But what would be the top? I mean, I suppose that no one can send dispatch one of their foreign nationals for an unlimited amount of time, maybe, let's say for 2 or 3 years in China, without actually managing to set up that new legal entity. So what would be the time tolerance for that?
Yes, as I mentioned, because the new system is distinguishing between more different types of categories of visas. So I mean, if a company doesn't have an entity within the PLC, then it's not possible for them to apply for work permits. And then for in terms of setting up an entity within the PLC, then the company might need to have apply for a other types of visa, maybe like a business visa or other types of appropriate types of visa to enter into China to do these types of activities. In terms of the time period, there's no specific time period which is allowed or not. But if you have some individual who applies for business visa on multiple times and then for a very long period, because of the new system is now more higher level of scrutiny. So the authorities will tend to be asking more questions, or and they're going to be more easy for them to monitor the foreign national why they are here for such a long time and just on business visa. So that's also something that needs to be bear in mind for someone who's coming to China for this type of activity.
And then maybe we've got quite a number of questions still, but maybe two final questions to be very practical. One of the questions is that the third labor contract with an employee has to become permanent unlimited in duration. Does that apply in the same way to foreign employees?
That does not apply to foreign nationals because of the rule that I mentioned, which is that a foreign national's employment contract with a local entity is only permitted to have a maximum term of 5 years.
Okay, so 3 contracts or more, it doesn't matter for foreign citizens then. Very good. And then the final one is, and I think we addressed that already in more details in the last webinar you spoke at with the EU SME Center, Johnny. It's about how the role of dispatching organizations like FESCO, CIC, STAR, etc. will change under this new setup. We've addressed that already for the system where dispatching will become more regulated, but that there are a number of exceptions for representative offices, for instance. Is there something that, I mean, of course, I'd like to invite the participants that are asking this question to also refer to our other earlier webinar, but if there is something you'd like to add on what we already discussed last time, in view of how you see the law progressing on that, it would be good to add it here.
In terms of the labor dispatch changes to that, it's not particularly it's a different topic because labor dispatch that is not implemented for foreign nationals. It's only for local PLC nationals that labor dispatch is going to affect. And in terms of labor dispatch, I mean the law is also came into effect. The changes yesterday. And then, there are also questions regarding the enforcement situation about the new law. And then, because the implementing regulation regarding the labor dispatch arrangement, it also hasn't been published, and that implementing regulation is supposed to specify the percentage allowed for dispatch workers. And then because it hasn't been published, it leaves some room for interpretation in terms of whether the labor authority is going to strongly enforce that labor dispatch, new rules regarding labor dispatch. So it looks like the enforcement situation is not going to step up immediately. It's like the new law regarding exit and entry of foreigners. The implementation regulation hasn't come out. So it looks like, and then there's also talk about the implementation regulation for the labor dispatch is going to give some period of grace period for companies to comply, and some has suggested 2 years. So it looks like the enforcement situation, at least in the initial period, is not going to be very strong. But then once the implementation regulation comes out, then need to monitor closely the developments on this area.
Thank you very much, Johnny. I think we've covered a lot of grounds today. We've actually even gone a little bit over the time that we have. So, of course, I'd like to thank you very much again for sharing your experience and your views on this very topical question, as mentioned again as at the beginning of this presentation, and as you did mention it a number of times, this new entry and exit law came into force yesterday, so it's all very new. Very important for SMEs to follow, and how this is going to change their practice. So definitely, it's essential to liaise with your legal advisor and your on HR issues further if you have more questions. If you have more general questions, of course, please don't hesitate to send them through to the center. We've collected the questions that you've already sent us through the webinar, and we get back to the ones that are registered on the website also already ASAP. If otherwise, I invite you to register on the website and raise the question after you're registered specifically on the website at eusmecenter.org.cn. Through the registration, you're getting free access to the Ask the Expert function, our knowledge base, the events calendar, as well as a number of databases we have, and other services that are mentioned on the website. Maybe a few announcements also upcoming amongst the number of events that are indicated on our website. On the 19th of July, so in a couple of weeks, the EU SME Center will be participating and contributing to the European Commission Mission for Growth to China, and we'll have an SME matchmaking session on that day, where there will be possibilities to meet with Chinese companies, local companies, but also with other service providers here. So if you're interested, please follow the link that is indicated here, b2match.eu, and of course the link will be available as we're sharing this presentation online within the next couple of days. Also on further HR, labor and employment issue, we have a number of further publications. I will not go through them in detail now, but there are guidelines, case studies, reports, a labor law database, as well as a number of webinars where we touched on other labor issues and HR challenges in China. And finally, the My People section on the diagnostic toolkit. So with this, again, I'd like to thank you, Johnny, for your availability. I'd like to thank everyone for their continued interest in the webinar. We're always open for further comments, and for that in particular, I'd like to invite you again to take the short survey that will follow the webinar. It's only taking you a couple of minutes of your time, and it's really helping us to identify further topics to cover in the future. So with this, thank you very much to everyone, and we'll see you again next week for our next webinar, which will address question of negotiation and cultural issues in contract negotiation. Thank you very much to everyone, and until next week then, bye-bye.